Good morning, Alex and friends. I'm Grace. Today is Wednesday, June 18th, 2025, and you're listening to Alex's News. The weather in Riverside today will reach a high of 95.3 degrees Fahrenheit, with the low dropping to 68.2 degrees. Remember to stay hydrated and seek shade if you're out and about. On Alex's News, we'll delve into the significant question of how unreviewable a president's power is when it comes to deploying the National Guard, examining the legal and practical implications. Then, we turn our attention to the important topic of privacy, looking at what health exchanges are doing with your sensitive personal data. All this and more is coming up on Alex's News. Stay tuned. We begin this morning with a profound legal and constitutional dispute that's currently unfolding in U.S. courts, focusing on the Trump administration's assertion that its decision to deploy National Guard troops and U.S. Marines to Los Angeles, California, is, quote, sole and unreviewable, unquote, by the judiciary. It's a true battle of the titans, pitting the power of the presidency against states' rights and the principle of judicial oversight. Joining us to break down this complex legal landscape is our reporter, Ethan. Ethan, it certainly sounds like a constitutional conundrum out there.
It certainly is, Grace. This controversy stems from President Trump's characterization of immigration protests in Los Angeles as a, quote, rebellion, unquote, that put, quote, lives at risk and property at risk, unquote. He argues this justifies the federalization of state forces. California's Democratic leadership, including Governor Gavin Newsom and Los Angeles Mayor Karen Bass, are challenging this, calling it an, quote, unprecedented, unlawful executive action, unquote, and an unnecessary overreach of federal authority.
So this is a major legal showdown. What exactly is the Trump administration arguing, and how are they justifying this claim that their decision is unreviewable by the courts?
The core of their defense rests on an interpretation of a rarely used early 20th century federal law, specifically Section 12,406 of Title 10 of the U.S. Code. This law, amended in 1908, governs the president's authority to call up the National Guard. According to reporting from LAist and ABC News on June 17, 2025, Assistant Attorney General Brett Shumate argued before the Ninth Circuit panel that the president possesses, quote, sole and unreviewable discretion, unquote, to commandeer state National Guard troops under this federal law, even if the president, quote, gives no reasons for doing it, unquote. He explicitly stated that courts have, quote, no role for the court to play in reviewing that decision, unquote. When pressed, he even confirmed that a presidential decision to call up the National Guard in all 50 states would likewise be, quote, unreviewable, unquote. This position was called, quote, astonishing, unquote, by Joseph Nunn, a national security lawyer with the Brennan Center for Justice, as LAist reported.
Unreviewable, even in all 50 states? That's quite the assertion. So what's California's stance on this, and what concerns do they have about such a broad interpretation of presidential power?
California's legal team, led by State Attorney Samuel Harbert, vehemently opposes the federalization. According to LAist and ABC News, they argue the deployment was, quote, unnecessary, unquote, stating that local law enforcement could adequately handle the protests and that the situation did not remotely amount to a, quote, rebellion, unquote. Harbert emphasized the federal government provided no evidence for such an extreme measure. California also highlights the significant strain on state resources. LAist and ABC News reported that one-third of California's National Guard, totaling approximately 4,000 federalized troops, are now in Los Angeles, diverting them from other pressing matters like combating wildfires and drug interdiction. CBS News reported California also warns that this interpretation grants, quote, unchecked power, unquote, that could be used against any protest or even in federal elections, trampling states' sovereign interests.
That certainly puts a focus on the phrase, quote, unchecked power, unquote. You mentioned this obscure 1908 law, 10 U.S.C. Section 12,406. Could you elaborate on what this statute actually says and why its interpretation is causing such a legal stir.
Certainly, Grace. The statute at the center of this dispute allows the National Guard to be called into federal service under specific circumstances: invasion, rebellion, or danger of rebellion, or when the president cannot execute laws with regular forces. It also states that orders, quote, shall be issued through, unquote, the governor. This phrase is a central point of contention. LAist noted its ambiguity. California argues Congress required gubernatorial consultation for such deployments and that proper notification was not given to Governor Newsom. The Justice Department, conversely, claims it went through the Adjutant General. Historically, the term, quote, rebellion, unquote, within such statutes has generally been left to the president's discretion, a precedent set in the 1827 Supreme Court case Martin v. Mott. However, U.S. District Judge Charles Breyer, who previously ruled against the Trump administration, found the civil unrest in this scenario fell, quote, far short of rebellion, unquote, finding the president's attempt to equate, quote, sporadic, unquote, violence with an organized uprising, quote, specious, unquote.
So there's quite a bit of room for interpretation in this old law. What's the latest from the courts, and where does this high-stakes legal battle stand right now?
Well, this case reached the Ninth Circuit Court of Appeals after U.S. District Judge Charles Breyer had previously ruled Trump's actions, quote, illegal, unquote, on June 12th, finding he, quote, did not, unquote, follow, quote, congressionally mandated procedure, unquote, and exceeded his statutory authority, according to ABC News and CBS News. Breyer's order would have returned control of the California National Guard to Governor Newsom, but this order was put on hold by the appeals court. The Ninth Circuit panel, which includes 2 Trump appointees and 1 Biden appointee, signaled it might have only, quote, limited power, unquote, to rule against the president's decision, appearing skeptical of California's arguments. The remote hearing was on June 17, 2025, and no ruling was issued, so it remains a very guarded situation, if you will. ABC News reported that another hearing before Judge Breyer is set for this Friday, June 20th, 2025, which is just 2 days from now. The federal government has indicated the case is likely headed to the U.S. Supreme Court, as LAist noted.
It sounds like this legal tug-of-war is far from over. Ethan, thank you for navigating us through this complex legal landscape.
My pleasure, Grace.
And that was our first story of the morning. We'll be right back with more news after the break. Welcome back, everyone. For our second story this morning, we're delving into a widespread privacy concern that has many Americans asking just how secure their personal health information truly is. We're talking about a significant data leak scandal involving state-run health insurance exchanges. Joining us to break down the details is our news reporter, Chloe. Chloe, this sounds quite serious. What exactly has been uncovered?
Grace, it is serious. As of today, June 18, 2025, a major privacy crisis has indeed come to light. Non-profit news organizations, CalMatters and The Markup, have conducted extensive investigations, revealing that numerous state-run health insurance exchanges have been transmitting highly sensitive personal health data directly to major technology companies like Google, LinkedIn, and Snapchat. This is happening through what are called embedded website trackers, which are tiny snippets of code website owners install to monitor user activity.
So these are the trackers we often hear about for targeted advertising, but in this case they're on health exchange websites? And they're sending sensitive health data? What kind of specific information are we talking about here, and who is receiving it?
Exactly, Grace. These trackers, typically used for advertising and site analytics, were found to be collecting and transmitting incredibly personal and confidential information when users visited these state-run health exchange websites and filled out forms seeking insurance. According to reporting from CalMatters and The Markup, this data included health history, prescription medications, medical conditions, and even highly specific details like pregnancy status or disability. Initially, in April 2025, The Markup and CalMatters identified that Covered California, the state's health exchange, was sending its users' personal health data to LinkedIn. Then, yesterday, June 17, 2025, A follow-up report dramatically expanded the scope, revealing similar practices in 4 additional states.
That's quite an expansion. Can you tell us which specific states were implicated in yesterday's report and what type of data they were found to be sharing?
Beyond covered California, which shared personal health data with LinkedIn, 4 more states were highlighted in yesterday's reporting. This data included names and sensitive health details like pregnancy status. Officials later admitted this data sharing was inadvertent. Nevada HealthLink was implicated for sending visitors prescription drug information to both LinkedIn and Snapchat. Its executive director also stated the collection was inadvertent. Massachusetts Health Connector was discovered transmitting data to LinkedIn. This data indicated whether a user was pregnant, blind, or disabled. Maine's CoverME.gov was found transmitting highly specific data to Google. This included prescription medications, dosages, and even users' doctors and hospitals. A spokesperson for Maine's exchange noted this tool is managed by a vendor. Finally, Rhode Island's health source RI was also sharing prescription and doctor information with Google. This was done through a similar vendor tool. Their spokesperson pointed out that Google Analytics is mentioned in their terms of use.
It sounds like a real data dump. How have these state exchanges responded to these revelations? Have they taken any immediate actions?
Thankfully, yes. Some have acted swiftly. Covered California, following the initial April 2025 report, removed the controversial trackers and announced a thorough review of its data practices. After being contacted by the journalists from the Markup and Cal Matters in early June 2025, Nevada's health exchange stopped sending visitor data to Snapchat and had reportedly ceased sharing data with LinkedIn in early May. Massachusetts also terminated its data sharing with LinkedIn upon being contacted. While Maine and Rhode Island acknowledged the use of these tools through vendors, their immediate actions were less definitive compared to Nevada and Massachusetts.
This all sounds incredibly concerning, Chloe. But is any of this even legal? My understanding is that health data is supposed to be highly protected under laws like HIPAA.
That's a great question, Grace, and it's where things get a bit tricky. Critically, state-run health insurance exchanges themselves are generally not considered, quote, covered entities, end quote, under HIPAA, the primary federal law for protecting health information. This means they are not directly subject to HIPAA's stringent privacy and security regulations. However, the insurance companies participating in these exchanges are covered entities and must comply. Adding to the complexity, a recent federal court ruling in Texas narrowed the scope of a Department of Health and Human Services, or HHS, bulletin. This ruling potentially weakens the argument that combining a user's IP address with their visit to a health-related web page automatically constitutes protected health information under HIPAA. So while a direct HIPAA violation is arguable, it doesn't mean these transmissions are immune. Other federal and state consumer privacy laws could still apply. Ethically, experts are very concerned, calling it a serious breach of trust for sensitive health information to be shared without explicit consent, especially for marketing. The tech companies involved, Google, LinkedIn, and Snapchat, have all stated their policies prohibit clients from sending them sensitive health information.
So while the legality is a bit murky, the ethical concerns are crystal clear. Have these revelations led to any lawsuits or formal investigations yet?
Yes, they have, at least stemming from the initial reports. Following the original reporting on Covered California, a proposed class action lawsuit was filed in the Northern District of California against LinkedIn and Google. This lawsuit accuses the tech giants of unauthorized interception of sensitive health information, alleging violations of both California and federal privacy laws. Furthermore, California Representative Kevin Keeley has publicly called on the Federal Department of Health and Human Services, HHS, to launch an investigation specifically into Covered California's data sharing practices. However, as of today, June 18, 2025, there have been no immediate public announcements of new class action lawsuits or formal investigations by federal agencies or state attorneys general in response to yesterday's reports about Nevada, Maine, Massachusetts, or Rhode Island.
It's good to know there's some legal action taking place. Given these are state exchanges, what was the intended purpose of using these commercial trackers in the first place, and were there alternatives that could have been used to avoid this whole privacy headache?
That's a very pointed question, Grace. The stated, non-nefarious purpose for installing these commercial advertising trackers was primarily related to legally mandated public outreach, advertising, and improving website functionality to boost insurance enrollment under the Affordable Care Act. The ACA broadly requires exchanges to conduct education and outreach. The exchanges seemingly chose these common commercial trackers to measure campaign effectiveness and understand user interaction. For instance, the executive director of Nevada's Silver State Health Insurance Exchange noted that trackers help target marketing at uninsured residents. However, the Affordable Care Act does not specifically mandate the use of commercial advertising trackers from companies like Google, LinkedIn, or Snapchat. There are plenty of privacy-preserving alternatives out there, including HIPAA-compliant marketing platforms, advanced privacy-enhancing technologies, or PETs, like differential privacy, contextual advertising, and server-side tracking with data de-identification. It seems they simply chose the most common tools, not necessarily the most privacy-conscious ones.
That's a bitter pill to swallow, knowing there were safer options. For our viewers who might be worried about their own health data now, what steps can individuals take to protect themselves from these kinds of trackers?
There's good news on that front, Grace. The markup in CalMatters also provided crucial guidance confirming individuals can take effective steps. You can adjust your browser settings. For example, Safari's advanced tracking and fingerprinting protection, and Firefox's enhanced tracking protection, especially on its strict setting, can block many trackers. Using privacy-protecting browser extensions like Privacy Badger and uBlock Origin Lite has also been tested and confirmed to block the identified trackers. And finally, switching to a privacy-focused browser like Brave or DuckDuckGo means these trackers are blocked by default. It's important to note, though, that some commonly used tools like a virtual private network or VPN won't prevent these trackers from collecting data, nor will browsing in, quote, private, end quote, or, quote, incognito, end quote, mode in standard browsers. These revelations really highlight the need for greater transparency from government agencies.
That's incredibly helpful advice, Chloe, and definitely gives our viewers a healthy dose of empowerment. Thank you for that very comprehensive breakdown of this evolving privacy story.
My pleasure, Grace.
We'll be right back after the short break. In Washington, a grim new report from the CDC shows the nation's fight against drug addiction is a hard habit to break. After a hopeful 17-month decline, U.S. drug overdose deaths are on the rise again. Provisional data shows an estimated 82,138 people died in the 12-month period ending in January 2025. This is an increase of about 1,400 from the year before. This follows an unprecedented 27% drop in 2024. Experts had attributed that drop to the wider availability of the overdose-reversing drug naloxone. They also cited a weaker strain of fentanyl. Now, officials are debating if this new uptick is a temporary blip or a more troubling trend. Some researchers warn the less potent fentanyl supply may be fading. Fentanyl remains the primary driver. However, the crisis is growing more complex. Dealers are lacing fentanyl with stimulants and veterinary tranquilizers like xylazine. The national increase appears to be driven by a handful of states. These include Texas, Arizona, California, and Washington. This highlights the need for targeted responses. Meanwhile, a potential toxic relationship is brewing within the Trump administration. The public health platform Make America Healthy Again, championed by Health and Human Services Secretary Robert F. Kennedy Jr., is clashing with actions from the EPA. While the MAHA initiative aims to eliminate toxins from our environment, the EPA under Administrator Lee Zeldin has been systematically weakening regulations. These moves include delaying national drinking water standards for so-called forever chemicals. They are also reconsidering the ban on asbestos. Furthermore, they are halting prohibitions on other hazardous substances like trichloroethylene. The administration has also cut the EPA's research budget. It has allowed petrochemical facilities to seek exemptions from pollution standards. Critics are baffled. Some of them had their own EPA research grants terminated. They point to the influence of the chemical industry. They call it a direct contradiction to the goal of a healthier America. Overseas, Russian President Vladimir Putin is set to take questions from international news agencies. This will happen at the St. Petersburg International Economic Forum. The rare roundtable with senior news leaders is expected to cover a range of hot-button topics. These range from the ongoing war in Ukraine to Russia's role in the Middle East. Since 2022, the forum has seen fewer Western executives. It has seen more attendees from Asia, Africa, and Latin America. Putin is also scheduled to meet with officials from China, South Africa, and the head of the OPEC oil group. Back in Washington, an Illinois toy company is not playing around. Learning Resources Incorporated has taken its fight against former President Trump's tariffs all the way to the Supreme Court. In a long-shot bid, the company is asking the court to expedite a ruling. It argues the tariffs were imposed illegally by bypassing Congress. The company says the tariffs are unbearable and forcing price hikes. These include a 10% baseline tariff and an additional 20% on goods from China. A lower court judge did rule in the company's favor. However, that decision was put on hold pending appeal. And finally, a major prescription for change in the opioid crisis. All 50 states have now backed a landmark $7 billion settlement with Purdue Pharma. This is the maker of OxyContin. The unanimous support paves the way for a vote by victims and local governments on the plan. Under the settlement, the Sackler family will contribute up to $7 billion. Purdue Pharma will be dissolved into a new public benefit company. This new company will make addiction treatment drugs at no profit. The plan allocates more than $850 million for direct payments to victims and their families. This new deal was reached after a previous version was rejected. That version shielded the Sacklers from future lawsuits. This revised plan allows those who do not opt in to retain their right to sue. That's all we have for now. Today's episode was made by Alexander King with Claude Sonnet 4.0, Gemini Pro 2.5, Gemini Flash 2.5, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.